Hi everyone, it's Alden Elizabeth here. As you guys may remember, when the new cannabis and DUI laws were coming out, we did a video to be able to inform you guys all about how they were going to affect immigration in Canada. We actually have some updates today that we want to go through. Before I get to the updates though, I just want to let you know that the video that we did do is now up on our website and it can be found here at this link. So please go to it to find out the full details of the cannabis laws and DUI laws and how they're going to be changing once this act comes into force. However, for today, we want to focus mostly on an update. This update is based on a letter that Minister Hussain, the immigration minister, had written to the Canadian Bar Association, essentially clarifying some of the questions that lawyers had about how the DUI laws were going to be enforced in Canada. I'm going to now hand it over to Elizabeth, who's going to go over some of the major points of this letter and why they are important.
Okay, so there are two main statements that the minister made to clarify how this act is going to be applied, especially to people who have received DUIs before the act came into force. And the act will come into force on December 18th of this year, 2018. So the first statement that the minister stated is that an individual who has already been deemed rehabilitated for an impaired driving offense outside of Canada before Bill C-46 comes into force, which will be December 18th, they don't need to apply again for deemed rehabilitation. So what that means is if you have a DUI, it's from outside of Canada, and it's your only offense, and it's been over 10 years since you completed the sentence for that offense, and you've already been determined to be deemed rehabilitated. You've already put your application to an officer, and the officer said, yep, you're deemed rehabilitated. You did that before December 18th. You don't have to do that again. You are still going to be deemed rehabilitated. Okay? The second statement that the minister made is if an offense of impaired driving has already occurred before the new penalties come into force on December 18th, and it was considered to be regular criminality, then it's going to be still treated as regular criminality rather than serious criminality. What that means is if your DUI occurred before December 18th, and if it occurred in Canada, you received a sentence of less than 6 months. If it occurs outside of Canada, it doesn't matter as much. But if you received it was in Canada, and you received a sentence of less than 6 months, it would have been considered criminality, and it's still going to be considered criminality and not serious criminality. So if your DUI occurs before December 18th and you receive a sentence of less than 6 months, it's still going to be treated as regular criminality and not serious criminality. For the difference of what the two means, go back to our previous video and it'll be explained there. And if you have any further questions, contact us. Here's our contact information, and we'll be happy to speak with you about it. All right, take care, guys.
Bye-bye.
Bye.